And it's just started. So we're going to go ahead and proceed just with the basics, and I'll check in with you when we get to the substantive part, okay? So can we still call the roll, or would you like us to just announce ourselves? Here.
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 Here. Thank you. I'm going to ask Commissioner Carson to please lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I think everyone here knows the basics of just remembering to turn off your cell phone, please. Only bring water into the courtroom. And if you would like to speak, I don't know that we really have very many visitors from the public, at least not at this early cold hour in the morning. Please let Ms. Wilford know. I would entertain a motion to approve the minutes from our December 8th, 2017 meeting. It's been moved and seconded. Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The minutes are approved. Moving into the meeting, and if it's not being fully projected or recorded, I think it's still worth us moving forward, but if you need anything from us, don't hesitate to interrupt. That would help. Consideration of final action on the matter involving Jody Strezick, item 4A on our agenda. Will the parties and their counsel please identify themselves?
Elizabeth Miller, advocate for the commission.
And is there other counsel? No one else is here. Ms. Miller.
Thank you. Jody Starozic was the district manager of Port Malabar Holiday Park Mobile Home Recreation District. He entered into a joint stipulation with the advocate whereby he admitted that he violated the anti-nepotism law by hiring one or both of his sons to work at the Holiday Mobile Home Park. He also admitted the second allegation that he misused his public position to benefit himself and or both of his sons. He agreed to a public censure and reprimand in the stipulation and to a civil penalty of $2,000 per allegation for a total of $4,000. And I respectfully request that you ratify the joint stipulation.
Moved by Commissioner Bonder. Is there a second? It's been moved and seconded. Sorry, that's a reflection of my long friendship with Commissioner Rosenka that I can call her Commissioner Bonder. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Motion passes and the stipulation is approved.
Thank you.
Moving on to the pre-probable cause stipulation regarding Jim Barfield. Counsel, please identify themselves and their clients.
Melody Hadley, Commission Advocate.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to accurately file a 2014 and 2015 CE Form 6 in violation of Article 2, Section 8, Florida Constitution, and Section 112.3144. We ask the Commission to accept the respondent's stipulation that he violated the aforementioned ethics code and recommend a total civil penalty of $1,750.
Questions of the applicant or Mr. Aaron? It's been moved and seconded that the joint stipulation be approved. Is there any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? Motion passes and the stipulation is approved. Thanks. Moving on to the motions to dismiss for lack of jurisdiction, matter 15-113 and Ray Kim Daniels. This is a motion to dismiss by the advocate based on a discovery that the complaint had been improperly accepted given its proximity in time to an election. I don't believe there's anybody here on behalf of the respondent. So Ms. Hadley, if you would please present the motion.
Well, the complaint filed in this case was received by the Commission on Ethics on May 15th, 2015, which was 4 days prior to an election day in which respondent was a candidate. Section 112.324, subparagraph 2F, Florida statute provides a complaint or referral under this part against a candidate in any general, special, or primary election may not be filed or may any intention of filing such a complaint or referral be disclosed on the day of any such election or within 30 days immediately preceding the date of the election, unless the complaint or referral is based upon personal information or information other than hearsay. Wording in the May 15th complaint indicates that it was based on hearsay. As such, the Florida Administrative Code Rule 34-5.001, subparagraph 5 states that the complaint should be returned by the executive director to the person filing the complaint with an explanation of why the complaint is being returned. While the complaint did not mention an upcoming election, its receipt within 30 days of the election meant that it should have been returned to the filer. This issue raises a question of subject matter jurisdiction, which cannot be waived. As such, I request that the case be dismissed for lack of jurisdiction and that the complaint be returned to the complainant with an explanation of why it's being returned as directed under the aforementioned administrative code.
Any questions for the applicant? If not, I would entertain a motion to adopt or to grant the motion to dismiss. Any discussion? Thank you for the well-stated motion. All those in favor, please indicate by saying aye. Opposed? Motion passes. It's dismissed. Yes. Thank you. The next matter, similarly on a motion to dismiss for lack of jurisdiction, is in Ray Jocelyn Reed, number 17-083. This also is a statutorily mandated investigation to determine whether an individual who failed to file the financial disclosure did so willfully. After this matter was sent to the Department of Administrative Hearings, the advocate received information from the agency that the respondent should not have been on the list of persons required to file. This was, as you know, a late addition to our agenda, and the materials were emailed to you, but if anybody needs any additional materials in print, let us know. Seeing none, Ms. Miller, would you make your presentation?
Thank you. Just as you said, Madam Chair, Mrs. Reed is a principal at an elementary school in Broward County. She failed to file her 2015 CE Form 1, and the maximum fine of $1,500 accrued. Later, it was determined that she does not possess the requisite spending authority to mandate that she file a CE Form 1. Therefore, I'm asking that the case be dismissed due to lack of jurisdiction. Thank you.
Any questions for the advocate? Commissioner Berger moves, excuse me. Commissioner Berger was making a motion to dismiss for lack of jurisdiction. Was that a second? Any discussion? All those in favor, please indicate by saying aye. Aye. Any opposed? The motion passes and the matter is dismissed.
Thank you.
The next matter under item 6A of our agenda is In re Ken Hagan, number 15-215. In this case, Mr. Hagan's petition seeks to have the complainant, Mr. George Neiman, pay attorney's fees and costs following the dismissal of the complaint against Mr. Hagan. If the petition is denied, as you know, the case will be dismissed. If the petition is not denied, then the matter will be sent to the Division of Administrative for hearings. I believe someone is here perhaps on behalf of Mr. Hagan. If so, would you introduce yourself?
Correct. Mark Levine on behalf of Ellsworth County Commissioner Hagan, and I would respectfully request to address the commission.
Let me just for a moment say that we have copies of the file in this matter and of the staff's draft of an order dismissing Mr. Hagan's request for attorney's fees. On January 16th, after the staff's draft order was distributed and the meeting materials provided to us, Mr. Hagan filed a document titled Response to Proposed Order Dismissing Petition for Attorney's Fees and Cost. Then on January 17th, Mr. Neiman, in response, filed another document via email. Our commission's rules relating to attorney's fees petitions does not allow or authorize responses to draft orders or responses to those responses, which is the situation we have here. So we will first hear from our staff as to whether these additional materials should be distributed. So if you'll hold on just a minute, Mr. Levine, let us hear from Mr. Gray Schaefer.
Thank you, Chair. I'm recommending that you not consider this documentation. As you said, there's nothing in the fees and costs statute or in the rule that was passed to carry out that statute that gives the parties the right to submit additional documentation at this stage of the fees proceeding. I want to emphasize this is just an informal proceeding concerning a very narrow question of law, whether the face of the petition sufficiently alleges the elements of the fees and costs statute. This is not a fact-finding hearing where the parties can present evidence. It's just an initial proceeding designed for you to look at the face of the petition and see if it alleges the statute's elements.
Is there any person on the commission that believes at this point that we should receive those additional materials? If not, let me ask, is Mr. Neiman here? Okay. So at this point, I'm going to invite Mr. Levine to address us, and if you would, limit your comments to 15 minutes.
Hopefully I'll be less than 15 minutes, Madam Chair. Madam Chair.
Mr. Levine, sorry, Ms. Doss gave me a procedural suggestion that we should hear from Mr. Schaefer first on his staff recommendation, then I promise to give you the chance to talk.
Whatever you would like.
So sorry.
Go ahead, sir.
Thank you, Chair. This case presents an issue seen before regarding whether a petition for fees and costs is facially adequate and sufficient to refer to DOA. Just as a reminder, the fees and costs statute is found in Florida Statute Section 112.317, subsection 7. It's very specific about what elements have to be pled in the petition in order for it to be found sufficient. There's 3 elements. First, that the underlying complaint contained false allegations. Second, that the false allegations concern material facts. And third, that the false allegations were knowingly or recklessly made at the time the complaint was brought. This language is very strict. Those elements must be present and adequately pled for the petition to be considered sufficient to refer to DOA. In fact, the rule concerning fees and costs says the elements must be set out with particularity, is the language the rule states, in order for the petition to be found sufficient. Because of that, it follows that a public officer can't automatically have their fee petition found sufficient just because you might have decided to dismiss it. In other words, just because you might find after an investigation that there's no probable cause of a violation and dismiss the complaint, that doesn't necessarily mean the underlying allegations were falsely or recklessly alleged at the time that the complaint was filed. So that's the statutory background. And if you look at the matter here, this dealt with a complaint that was brought against Commissioner Hagan, who's a Hillsborough County Commissioner, was brought by Mr. George Neiman. And the underlying complaint by Mr. Neiman was consolidated with 3 other complaints against Commissioner Hagan. Although for whatever reason, the commissioner is moving for costs and fees just on the complaint filed by Mr. Neiman, even though all the complaints were nearly identical. Now in his complaint, Mr. Neiman alleged several things. 2 of them were found material for an investigation. First, that in exchange for receiving free political consulting from a political consultant, which the complaint alleged was not reported as a gift. The commissioner ensured that different county projects would be referred to contractors who would subcontract work on that project to the same consultant. The allegation was that the commissioner was receiving free consulting services that he did not report in exchange for ensuring this consultant would get more business. Second allegation was that Mr. Hagen, the commissioner, was receiving these consulting services while that consultant was providing similar services to the county. So that presented some conflict of interest concerns. Now, the complaint was fully investigated, and after reviewing the ADREC, you all found there was no probable cause of a violation because there is insufficient evidence to support the allegations. That's the background. But again, just because you found no probable cause, that doesn't necessarily mean this fees petition is necessarily sufficient to refer to DOE. To recover fees, the commissioner had to be able to allege in the petition not only that it contained false allegations, but that Mr. Neiman knew when he filed the complaint that it contained false allegations, or that he filed the complaint with reckless disregard as to whether it contained false allegations. And I'm recommending you find those elements are not present in this petition. If you look at the petition, nowhere in it does Mr. Hagen, Commissioner Hagen, specifically allege with particularity that the rule requires that Mr. Neiman knew at the time he brought the complaint that either of these two allegations were false or that he acted with reckless disregard as to their truth. Instead, the petition just makes a very general allegation that the complaint contains false allegations and that Mr. Neiman knew or should have known they were false at the time he filed them. Now, to me, this is conclusory. It repeats the language in the statute, but there's nothing specific in the petition alleging why the commissioner feels Mr. Neiman knew the two allegations were false at the time he filed the complaint, or why he feels Mr. Neiman brought those allegations with a reckless disregard to their truth. Essentially, the petition just generally alleges that the complaint contains false allegations, provides no support for that broad assertion, and then requests a hearing at DOA. If that's all that's needed to find the petition sufficient, nearly every public officer who has a complaint dismissed could obtain a DOA hearing on fees. For that reason, because I don't believe the petition is adequately pled, I'm recommending that it should be dismissed. I do want to note a few things very briefly. First, the petition does allege Mr. Neiman had no personal knowledge of the allegations of the complaint, but found out about them from news reports. The petition implies Mr. Neiman was acting recklessly because he was basing the complaint on what he'd heard from others. But there's no requirement in the ethics rules or in the code of ethics requiring personal knowledge to bring a complaint. You often accept complaints based on news reports or secondhand knowledge. To facially plead the statute here, the petition would have had to substantially allege Mr. Neiman knew those news reports were false, but filed his complaint anyway. Also, the petition asserts Mr. Neiman and other individuals have abused the commission and other agencies by filing a series of complaints against Commissioner Hagen, all of which have been dismissed. But again, we aren't dealing with a prevailing party standard here. Just because a complaint has been dismissed, that doesn't necessarily mean the party filed it with knowledge that it was false or with a reckless disregard as to its truth. So I don't believe all the elements of the statute have been facially pled here in the petition. I'm recommending you dismiss it. If you have any questions, I'm happy to answer.
Thank you, Mr. Schaefer. Why don't we hold our questions, if there are any, from Mr. Schaefer until we've had the opportunity to hear from Mr. Levine, finally. Thank you. Sorry to have given you a false start.
Thank you, ma'am. Madam Chair, members of the Commission, staff members of the Commission, Mark Levine on behalf of Commissioner Hagen in Hillsborough County in this regard. Anybody in this room who knows me would clearly agree that I would be the last person ever to advocate thwarting a citizen's right to exercise their right under the Florida Constitution and Florida Statute 112 to seek redress of violations of the public trust. I believe in that strongly, have always believed in that, and have advocated that with this commission over my years of practice. But with that right, I've always felt like there came a responsibility to ensure that the allegations are well-founded and go to a material violation of 112. Due diligence on the citizen's part, I believe, is inherent before placing a public official in the position of defending many times baseless and spurious charges. These charges revolve around Commissioner Hagen, primarily relationship with Ms. Latham, on a county project that the complainant strongly opposed publicly in front of the county commission. The complaint states that Ms. Latham had an improper relationship with Commissioner Hagan by providing free paid consultation services, lobbying on the Parsons-Brinkerhoff contract, and potentially a violation of the public records law. I was involved in the investigation in regards to the public records law, and there was no violation. There was no proof or factual basis for proof, no specific instances of conduct alleged by the complainant, just a general, broad, sweeping set of allegations. If you read the complaint, you will see that your executive director asked for an amended complaint from Mr. Neiman. The amended complaint basically states the same thing as the original complaint. As your counsel has quite frankly told you, the other three complaints that were consolidated with this are nothing more than a mirror image of Mr. Neiman's complaint. The issue of the, quote, news stories is in Mr. Neiman's response to my response to the petition. That's not our understanding. Our understanding is it did not come from a newspaper, or it did not come from a television story. It came from a specific, quote, tip from a news reporter. That's what is been told to your investigator in the investigation, in the investigator's notes, and I've confirmed that with Keith, that it came from a tip like me telling you. It was not what was based upon in the public forum. In fact, if the allegations in this case were true, the allegations would be criminal in nature. At the time these allegations were made, Mr. Neiman knew that the Florida Department of Law Enforcement, the Hillsborough County Sheriff's Department, and the State Attorney's Office in Hillsborough County were doing a thorough investigation, hundreds and hundreds of pages of documents in regards to the same and similar and additional allegations made against not only Commissioner Hagan, but other members of the county commission, and I believe the mayor in that particular situation. Did Mr. Neiman wait till that investigation was complete? It was a public record, it was a public document, and review that and determine then whether he thought that there were sufficient allegations for him to proceed in this particular forum. Also, he raised issues in respect to the conduct of Commissioner Hagan, which would have been dismissed by this commission because they're properly in front of the Florida Commission on Florida Elections Commission. But those allegations were made here. Did he ever go to the Commission on Elections and ask to pull the financial reports, ask to pull the in reports? He states with particularity that Commissioner Hagan had a voting conflict because of his relationship with Ms. Lehman, because he voted for the Parsons-Brinkerhoff contract. Well, Mr. Neiman was at all of these meetings. The commission never voted for the Parsons-Brinkerhoff contract. That's confirmed by your investigator. The county administrator directed that contract without the commission's approval. The only thing the commission did was at a subsequent date, they approved an amendment to the contract. So the due diligence that is lacking in this complaint is absolutely overwhelming. Now let's talk about pleading for example. I'm a student of notice pleading. I know Mr. Norris is a lawyer. He understands what that is. Others of you may be lawyers. I was mentored by a very esteemed circuit judge here in Leon County as I grew up as a lawyer to provide notice pleading. Is it sufficient for me to just say that the complaint was filed maliciously or that there was no basis in fact? I believe that the burden shifts to me to prove that through the discovery process. I can't prove it to you based on the face of the complaint because the complaint in itself is not specific. I think Ms. Doss had issues with it when she asked for an amended complaint. I believe the thing should have been dismissed out of hand, being a failure to meet the standard for legal sufficiency. But the commission moved forward, complete investigation was done. Commissioner Hagan has had to deal with this for 2 years. He has children in public school in Hillsborough County. He gets in the newspaper. It's alleged that he's done something terrible. He's had an improper relationship. His children come home. You know, they're not very happy. Daughter crying because somebody said, well, your dad's a crook. Well, I have the opportunity here to go through the discovery process and to take the depositions, and I must prove to an administrative law judge that these allegations meet the standards required by the statute in your rule. I can't state, I am not going to state with particularity something I do not know in a petition to this commission. That is not right. It shouldn't be done. Now, if counsel in their esteemed look at this matter thinks that I have not pled it properly, then what you should do is give me an opportunity to amend. It's routinely done in circuit court. Been there, done it several times. Filed motions to dismiss, leave to amend. If that is what it is the elements, I cannot, and nobody can, standing here in front of you in any petition of this nature, tell you and plead to you in a pleading maliciousness. It's not the Sullivan standard, we understand that. It's the Brown standard, which is something less. I can't give you specifics until I get into discovery, till I get into Mr. Neiman's mind and find out what he knew, when he knew it, how he knew it, and what he thought about it. So in this particular circumstance, if you feel like and agree with your counsel that it's not sufficiently pled, I would respectfully request 30 days to file an amended, just as you gave Mr. Neiman 30 days to file, or you gave him time to file an amended petition. The Brown standard, I don't need to show actual malice. I'm sure you're aware of that. So I would respectfully request that the petition is sufficiently pled. If you don't agree with my assertion and agree with counsel's, that I would respectfully request leave to amend my petition so that I might address the issues raised by your esteemed counsel here at the table.
Thank you. Before you step away, Mr. Levine, let me just ask if the commission has any questions. Thank you very much for your presentation. Any questions for Mr. Schaefer?
I'm
Go
sorry,
ahead,
Madam
Mr. Parson.
Is that an option, giving him an opportunity to amend?
There is, Commissioner, there's nothing in the statute or the rules that discusses amending a facially insufficient fees petition. But I'd be remiss if I didn't point out to you something in the Administrative Procedures Act, Section 120.569, subsection 2C. It does allow an agency to give a party the chance to amend a facially insufficient petition at least once and without prejudice to cure its defects, unless it conclusively appears in the face of the petition that the defect can't be cured. Now, Mr. Levine seems to indicate that there's no way for him to get inside Mr. Neiman's mind outside of a hearing in DOA where he can conduct discovery. So, you know, it's up to you whether or not then he would be able to have the ability at this point to cure the defects of the petition.
Well,
Commissioner Norris.
there's nothing in the statute that prohibits allowing an amendment.
No. There's nothing that addresses it in the Code of Ethics or in the rule. We just had that statute in the Administrative Procedures Act.
Thank you. Commissioner Norris?
Madam Chair, I move to dismiss with leave to amend 30 days.
It's been moved and seconded that the respondent have the opportunity to amend his petition, but that the matter be dismissed until that point. Is there any discussion?
Madam Chair.
Hold on just one second. Commissioner Brady.
The level of specificity would have to very much identify what particular element of the complaint was, the complaint was knowledgeable in terms of having done it maliciously. I mean, just so I understand
What the rule says is that the elements of the fees and cost statute have to be pled with particularity in the fees petition. And just to clarify, that's a different and more strict pleading requirement than what's required in an ethics complaint.
So in the petition, there would have to be presented evidence, a statement that said, we talked to somebody else and they told him that he really wanted to get this guy's reputation.
There would have to be something in there to substantively support the allegation that that Mr. Neiman knew that those claims were false, but still filed the complaint anyway, or act with a reckless disregard as to their truth. Just a blanket allegation repeating the language of the statute, I don't believe that would be a sufficient pleading.
Commissioner Carson.
Thank you. If I could, Mr. Schaefer, thank you for your last response. I didn't properly thank you. Is there any, I think this is potentially one of the problems of having so many lawyers on the commission.
Just one of the problems.
My natural instinct is to try to tie this to some sort of pleading standard in federal or state civil litigation. Is there any connection at all, any guidance you can give me there? Is this a, and not your opinion, but, has anyone who's looked at this issue said this is akin to, the federal pleading standards? You can't just recite the cause of action. You have to, I think the federal cases on that, the Iqbal standard, the Twombly standard, is there any connection with that? The reason I ask is because I want to make sure that the second, if the commission passes this motion and the commissioner is given an opportunity to file an amended petition, I want to make sure that it's clear what it is we would be looking for in an amended petition, if it's possible. It very well may not be possible, as you've cited. I want to make sure that what the specificity and the particularity required is to make sure that that's known to the petitioner.
I'm not aware of anything that would specifically tie those standards together. The Brown case from 2007 and the Hadid case, which I believe was issued from this court 2 years ago, they don't go into the specifics of the pleading requirement necessarily. They talk just more generally about the language of the statute itself.
Madam Chair.
Do you want to say something, Ms. Doss?
No, I was just looking at Chris because he looked like he wanted to say something.
Thank you, if I might, through the chair. There have been examples that you've heard fairly recently of petitions that were facially adequate. And it hadn't been too many meetings ago when the person that filed the petition, there was this sort of discussion going on, and the attorney was able to point to particular things in the petition of a factual nature that alleged that, for example, fact A was obvious, or fact A was known to the complainant, and yet the complainant disregarded fact A and turned it on its head and made it into the opposite, 180-degree allegation. When it's that sort of thing, it's more of a factual presentation from the complaint coupled with a factual allegation of the reality that the complainant was aware of or should have been aware of, or his recklessness or his actual knowledge of falsity. It hasn't been analyzed in the ones that you have found sufficient to go to DOAH. It hasn't been analyzed with the nature of any sort of federal standard or state standard or notice pleading or common law pleading or medieval jump through the fire pleading or anything like that. It's been more of just plainly, is there not just a conclusory assertion, but is there a factual tie to what the complainant actually knew or basically should have known versus what he or she put down on paper.
Thank you, Mr. Anderson. Commissioner Brady and then Commissioner Norris.
In the event the current motion is defeated and the motion is made to accept the staff recommendation, what recourse does the respondent have in terms of pursuing this matter? Can they do another petition to us? Can they go into circuit court and sue people? Or is it just basically this is it?
I think I know the answer, but I should defer to the Executive Director, Ms. Doss.
They can't bring another petition before this commission, but they have whatever civil remedies there are, which I imagine would include libel or slander if they feel that that's occurred.
Commissioner Norris.
To our counsel, what strikes me about the language with regard to particularity is it tracks the language of the civil procedure rule for pleading fraud. And so the concept, as I understand that, in the pleading sense of civil procedure is that, well, you cannot simply say, the the bad guy has committed fraud, period. And so now I've sufficiently pled fraud. You have to establish some elements as to why that would constitute fraud. And so it seems to me that that would be an appropriate marker, if you will, for us here. What's your view of that, Mr. Schaefer?
I haven't reviewed that particular, those rules. I do understand what you're saying, though. It sounds like there might be a parallel there.
Any other discussion? Commissioner Berger.
Just a point. Listening to the discussion and motion on the table, from my perspective, what I'm hearing is there's nothing in the rules from preventing Mr. Levine from amending the petition. And when he does such, that may affect the analysis. It may not affect the analysis. But until we see that amendment, we don't know the answer to that. I mean, it may affect Mr. Gray's analysis. It may affect it in no way, shape, or form. It just depends on the petitioner's filing.
At this point, I think we're probably ready for a vote unless there's any other comments from the commissioners. All those in favor of the motion to dismiss, giving the respondent 30 days leave to amend, please indicate by saying aye.
Aye.
Any opposed? The motion passes.
Madam Chair, may I query?
Yes.
It's important, I think, obviously you've been engaged in this discussion as a commission. How quickly can I get an excerpt of the record so that I can follow the discussion from this agenda item, so I can make sure that I understand exactly what you're looking for and what council has so adequately set forth to you? How quickly can I do that?
Carrie, do you happen to know the answer? You're the only one I can see over there.
Oh, today? Okay, and how do I do that? Would you have my email address on file? Could you email it? And if there's a cost involved? And by the way, the answer to the question about if you...
I think we're good. I think we should stop where we are because they can still make another move right now. So my suggestion is we wrap this up, we'll get you the record and go from there. Thank you for your time, and thank you, Mr. Schaefer and Mr. Anderson, for your input. Moving to item 7, the consideration of advisory opinion. We just have one today. This is file 2707, and I'll ask, is the requester here? Doesn't matter. Could you introduce yourself, sir? Thank you, Mr. Carthy, for being here. And I'm going to ask Mr. Anderson if you would please make this presentation on the opinion.
Thank you, Chair Ankers. This is pretty straightforward post-employment restriction opinion that this gentleman has asked for, and I inquired as to the facts of the nature of his employment and who he worked for, and he worked for the Florida Housing Finance Corporation, I think is the current name of it. And it's one of those technical things about whether you fit a certain definition in the statute, and based on his work history and where he worked and the type of category of employment that he did not have, either directly or by analogy, the draft opinion recommends that he's not subject to the 2-year post-employment restriction. And it's, kind of follows on the heels of one that was issued not long ago to an administrative law judge at the Division of Administrative Hearings, and you would think, okay, that's a lofty position. That sort of person, shouldn't they be subject to a post-employment restriction? In that case, we found that an administrative law judge would not be, based on the analysis of the categories of the definitions the legislature has set out. Analogously, that's the case with the requester today, and I would urge, I would just offer the opinion for your consideration as drafted, but basically I think it's a pretty straightforward rationale, and if you have any questions, I'll be happy to try to answer them.
Any questions for Mr. Anderson? If not, I would entertain a motion regarding the opinion. Motion by Mr. Berger to adopt the proposed opinion. Is there a second? I'll second. Any discussion? All those in favor of the motion to adopt the advisory opinion as written, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the opinion is approved. Thank you, Mr. McCarthy, for taking the time and effort to make the inquiry. I appreciate it. We'll move now to item 8 on the agenda, consideration of financial disclosure appeals. There are no cases in which the appellant has requested a hearing. Does any commissioner wish to take up any of these individually? Hearing none, I would entertain a motion to adopt the staff summary recommendations.
Move to adopt the summary recommendations in NOS.
Is there a second?
Second.
Is there any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. The last and easiest matter, perhaps, on our agenda is the adoption of our annual report for 2017. Are there any questions from the commission for staff? If not, I would also entertain a motion that this be adopted as our annual report.
So moved.
Is there a second? Too bad. It fails.
Second.
Is there any discussion on this? Commissioner Rosenka, she just seconded it.
Yes, I second.
Yeah, we're good. We're not that desperate yet. All those in favor of the motion to adopt the annual report indicate by saying aye.
Aye.
Any opposed? The report is adopted. I will ask our executive director if she'd like to make a report about what you've been busy with lately.
Nothing new on the executive director's report. I just want to point out that in our continuing effort to recruit as much unpaid help as we possibly can, Vice Chair Cox spoke at the Seven Springs Rotary Club about ethics in this last month. So beware, you could be conscripted at any time. As to the legislative report, as you have seen, things happen very quickly and then nothing happens. So I'll give you the latest on where we are. We have a Senate Bill 1750, which does exactly what we wanted with respect to attorney's fees and voting conflicts, adopts the commission's recommendations completely. It has no House companion, and it's assigned to 3 committees in the Senate. Hasn't been heard by any of them. We have a bill filed by the same senator, which would deal with applying the ethics laws to privatized health managing entities, community-based care lead agencies, and aging resource centers, which was Commissioner Brady's recommendation. Adopts that, also has no House companion, and is assigned to 3 committees. We have a Speaker's priority bill, which has to do with economic development and tourism development entities. They call these entities agencies, although they're really almost always private companies that contract with local governments to do tourism and economic development. That's on the calendar in the House and will surely be passed. Its companion is assigned to 4 committees in the Senate. It's a difficult bill because it only applies the ethics code to these agencies in respect to their contracts with the local government entities. So it could be difficult to administer, but we're just watching that. We haven't been asked to speak or made any recommendations one way or another on that. There's a bill out of the Senate, and there's a House companion which would make sexual harassment by officials or lobbyists a violation of the Code of Ethics. It presents a challenge because sexual harassment is a discrete body of law with a lot of its own terms of art and its own interpretations, hostile working environment, offensive working environment. Those are things of which this staff knows, well, I'll say very little, but that's just a nice way of putting it. We know nothing. I have been working with the Senate staff people on some ideas where we could potentially beef up the misuse of position law to encompass some of these, perhaps not all of what she has in the bill now, but I haven't been able to get an appointment with the Senate sponsor yet. There was a big bill, perhaps you remember, 7003 out of the House. That's the one with the fluctuating standard for financial disclosure. That's the one that puts the Ethics Commission in charge of everybody who wants to lobby local government entities, all 1,500 and something of them, and that relaxes the gift law. That has been passed in the House. The House's other big ethics bill, 7007, has only been referred to one committee, and I have no doubt it will pass. Both of these passed last year out of the House. The two bills have been combined in a Senate companion, which has been referred to 3 committees. I've been speaking with Senate staff extensively about this bill, and I'm trying to get a meeting with the sponsor as well. And then last but not least, to end on a kind of a happy note, I think here, there's a bill in the House, 815, which would require Form 6 financial disclosure for local elected officials. And I was stunned when this came up in committee at the support by the members of the committee for this concept. They're all like, why aren't local elected officials already filing Form 6? That bill has also a lot of travel stuff in it for locals that some of the committee members weren't as excited about. And it has a requirement that the Ethics Commission be the repository for travel expense reports for all the 67 counties and the 467 cities that I'm not that excited about, but I've been working with the House sponsor, or his aide actually. He's on deployment till the end of the month, and they've been very nice. I'm hoping we might be able to get something that works better for everyone on that aspect of it. But I mean, I was just really surprised at how much support there was for the Form 6 issue. There is a Senate companion. The House has just gotten out of its first committee. It's assigned to 3, I think. And the Senate bill has 3 committees and has not been heard in any of them.
How many local ethics commissions are there in the state?
I don't know exactly. There's Miami-Dade, Palm Beach, Jacksonville. I think there might be one in Broward. That's all that I know of. Anybody else? Yeah, that's all that I know of.
Commissioner Brady.
Do you have a sense of the thinking on making sexual harassment an ethics violation? I mean, is it a belief that this kind of gets it out of their house, puts it in somebody else's house?
Through the chair, I do. The Senate sponsor of this bill, which I think is where the genesis was with the Senate sponsor, is someone who's had personal experience with sexual abuse. She's very active in protecting children from abuse. She is very motivated. I mean, this is not, I think, a bill that some constituent or business came to her with. This is personal for her. The Senate, as you know from news articles, has had some issues of late, and I think the concern is that the victims of this, be they women or men, feel like they have no place to go that will give them any protection from retaliatory action. Part of the issue, or my concern with this bill, is we don't give them any protection from that either. So just having one more outlet maybe not help them as much as she's trying to do. But that's kind of where the genesis is. It's all part of the, that being in the public eye right now.
And the reason we don't provide any more protection, anything else, is simply that once we make a decision, then it becomes part of the public record, that it's confidential, hypothetically, until we make a decision, but once we make a decision, then it's part of the public record.
Through the chair, that's not really it. It's just that we have no ability to protect them from retaliation. Typically, even if we keep the information of the complainant confidential, or the victim, if that victim happens to be a witness, the person accused is going to know who it is, and they have to. I mean, it would be a violation of due process not to tell the person accused. So the thing is, we can't keep them from firing that person or demoting that person or otherwise mistreating that person.
Any other questions for Ms. Doss?
Thank you for
Commissioner Berger.
As our rules are on the books now, misuse of position is the best area to cover these types of situations for our dealings.
Yes, through the chair, we have prosecuted cases of what would ordinarily be called in the vernacular sexual harassment. If an official uses or attempts to use his position to coerce a colleague, employee, lobbyist, or anybody else into sexual or romantic conduct, been seen as a benefit to the official, and it meets the elements of misuse of office. The advantage there, because I prosecuted some of these cases, is that you have those three elements of misuse. You don't have to, and opposing counsel often try to get into federal regulations, interpretations of sexual harassment law, and all I usually had to do was direct the administrative law judge's attention back to the fact that we weren't talking about sexual harassment. We're talking about misuse of position. Here's the elements. That's all we have to prove. So to the extent that roping in sexual harassment would turn it into a potentially muddier issue, it could be a problem. But if we can possibly beef up the misuse of position law by specifying that sexual conduct is a benefit, I'm hoping, I haven't met with her yet, maybe she's watching, but I'm hoping that, you know, that will help us both.
Thank you, and thank you, Ms. Doss, for running the ball for us legislatively. At this time, is there any other business to come before the commission from any of the commission members? If not, we'll stand adjourned and reconvene for the private session at 9:30. Thanks. We're adjourned.